Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everyone in between. I'm Dan Balkaran, and I'm going to be your employment lawyer for the next 30 minutes or so. We've got some questions rolling in. There you see my name on the screen. I'm an associate at Samfiru Tumarkin, LLP, which is Canada's largest, or I should say leading employee side law firm in employment law firm in the country. Okay, as always, a little bit of housekeeping. You can reach us whenever you want at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Okay, great. All right. Well, we've got one question. Please send in all of your questions so I can get to them in the 30-minute block that we have today. Okay. Question from Ja Rule. What about persons who were terminated because they didn't take the vaccine? Are they entitled to any severance pay? Well, this is for some reason, after not talking about vaccines, this is the topic du jour today. Okay, so there's not a single legal decision across Canada that talks about termination without notice, no severance pay for refusing to comply with the vaccine mandate. Now, there is a decision out of BC. There's only one, and that's only one across Canada, that says that an unpaid leave, a situation where an employee who refuses to comply with a mandatory vaccine policy and is placed on an unpaid leave, an indefinite unpaid leave, that the mandatory vaccine policy was reasonable, and therefore, because it wasn't a termination, it was also reasonable for the employer to place that employee on unpaid leave, even though there's no such thing as an unpaid leave, and a suspension in pay is effectively a termination, or at least it was up until COVID. And so the underlying policy animus of that decision said that so pandemic was once in a 100-year event. Everyone was just doing their best, and this is what the doctors said was the best thing. And so in the context of an unpaid leave, vaccine policy was reasonable. There is no decision about what happens in a termination. And the question is, well, if the policy is reasonable, would it also be reasonable to terminate? Or, and particularly in cases where, because a lot of employers all of a sudden found themselves later on in the pandemic having a shortage of employees and an employee crunch. And so they, 8 months later, a lot of them just rescinded their vaccine policies. And so the core of the just cause analysis, so just cause simply means your employer can terminate you and pay you nothing, is that the relationship between employer and employee is irreparably and permanently broken. Okay. And so if the employer rescinds the vaccine policy, mandatory vaccine policy, a few months later, 8 months later, whatever it was, how could it be permanent? How could the relationship be permanently broken? And the courts haven't wrestled with this question yet. It's surprising that they haven't, but they have not. And so the answer is, I don't know. I think that there's no way, if the policy was rescinded, there's no way that you could say that the relationship was permanently broken. But at the same time, the public policy underlying, or animus underlying that legal decision on unpaid leaves in the vaccine context, talked about how everyone was just doing their best, and this is what the medical advice was, and it was a once in a 100-year event. And so, I can't tell you how that's going to go. There is certainly a path to employees who are terminated for just cause for not getting the vaccine to getting severance. I can also see a situation where they don't get severance. And so I don't have a firm answer for you on that one. I think it is something that is still going to have to be decided before the courts. I think that for you in particular, I think that you have to look at what the potential severance amount that you get would be. So if you have 2 months of severance coming to you, it's probably not worth taking on the risk of moving that case to trial, or at least bringing that case forward. But and by this point, you're going to get close to the end of the 2-year limitation period anyway for filing a lawsuit. So you'd have to, you might already be past it. So I encourage you to get legal advice immediately on that particular question. But if you've got 24 months of severance coming to you, or some huge amount of money, yeah, you're going to want to file an action right away and pursue it. So, Ja Rule, I would contact an employment lawyer immediately. If I were you, you can contact us if you'd like at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Thanks. Liz asks, who decides that it is in fact a constructive dismissal? I say it is, and HR says it isn't. Well, the answer is the judge. The judge decides if it's constructive dismissal. But most cases settle. The vast, vast majority of cases settle. And so if you claim that you have a constructive dismissal, so constructive dismissal, Liz, I think it will assist in just rehashing what that is. So constructive dismissal is where there's 2 ways to get there. So I'm just going to back up 1 second. Why you claim constructive dismissal is because you want severance money. Okay? To get severance, you have to be terminated without cause. If you're terminated without cause, then you're entitled to common law severance unless you contract out of it into something different. Okay, so and then it's just a formula to assess. It's just an assessment of how much money you get. Okay, but in a constructive dismissal, there's a first step in front of that, which is, does a judge think that the actions of the employer were constructively terminated your employment? Okay, and so there's 2 ways to get there. One is where the employer breaches a fundamental term of your employment, and the other, such that in effect your employment has been terminated, and the other is that the employer indicates that it does not want to be bound by your contract of employment, and some cases have both. And so you have to figure out which branch you're under. Now, with the first branch, that's sort of, it's easier to explain it with an example. It's when you're talking about a breach of a fundamental term. So, classic example: your employer reduces your salary by 40%. Is that a termination? Yes, it is. Or your hours by 40%, reducing your compensation by 40%. That's a termination. Gets a little trickier, but it could be a relocation, could be a schedule change. If you've got those are very hard, but if you have child care responsibilities, elder care responsibilities that the schedule change conflicts with, and you bring it to the employer's attention, also the and this is the hardest one, generally speaking, under this branch, is a demotion. So it's demotion is easier, but if it's a demotion but not in name. So if there's a demotion where you were CTO, now you're janitor, and these were your duties, and now your duties are effectively nothing. That can, or let me put that a different way. So demotion plus salary cut, generally going to make out a constructive dismissal. But if nothing changes with your pay and your title, but your duties are hollowed out, so you did have CTO duties and now you just sit at a desk looking at documentation, that could also be a constructive dismissal, but those cases are quite hard. So it depends, and constructive dismissals are going to turn entirely on the facts. And so I don't think anybody should pull the trigger on a constructive dismissal without getting legal advice. They're too hard. They're too complicated. And so, Liz, you have effectively asserted constructive dismissal. And so if you are correct, you're going to have some entitlement to severance. We just don't know how much. But if you're incorrect, you in fact resigned, right? And so there seems to be an argument going on between you and HR right now about it, and it is entirely possible that you could just keep working there if you wanted. So, Liz, I strongly recommend that you talk to an employment lawyer immediately. If you need to reach us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Thanks. Uh, Sir asks, are there different employment rights for remote workers versus in the office? I don't know what you mean. No, I mean you're all still employees. It could be that vaccine mandates apply differently, although it's not clear that they do if you're working remotely, because how are you a health and safety risk to anybody versus those in the office? But and maybe you're talking about, do you have the right to work remotely as opposed to being forced to come into the office? And the answer to that is, if you were hired specifically into a remote position, likely after the start of the pandemic, then you may, in fact, if they force you to come back to work, you may have a constructive dismissal. I think that I mean, you could try that, and certainly you might have a case on that front, but uh, I'd have some concerns about that. I'm not sure there's any case law directly on that in support of someone was hired. I mean, this is also new, right? Because the pandemic just happened, but I don't know if there's any law on that particular point for a worker who asserts that it's a constructive dismissal because they're being forced to come back to the office because they were hired into an exclusively remote position. Um, but for those employees who predated or long predated in that employer the pandemic and then worked remotely during the pandemic, and then the employer said, "Come back to work." No, you don't have a right to not to work from home. There's no defined right in law to work from home at this point in time. Lily asks, "What can you do if your employer lets you go while you're preparing to go on sick leave?" Well, that's an interesting question. Did they know you were preparing to go on sick leave? Because if they did, this might be a preemptive strike. I've seen that happen uh, more than once, where an employer looks at it and goes, "Well, this person is sick, or could be an ongoing problem, but they haven't formally brought it to our attention, so let's get them out of here." Or, "We suspect this person has an addiction issue, an emerging addiction problem. Let's get them out of here." Um, so it depends on if you can establish that your employer knew, and then if that's the case, wait, I mean, you're going to have a severance claim anyway. It's just, is your severance claim limited to statutory minimums, or some amount other than the common law? And so you'll need to talk to a lawyer. Common law is, of course, it's the bigger severance, which is an assessment by a judge of your age, length of service, position, and how long you're going to be unemployed for. Um, uh, Sort of divided or subtracted from how hard you look for a job. So it's a sort of a quantum assessment of how much you're owed. Um, so you're going to need to talk to an employment lawyer to find out if you do in fact have a right to common law severance, and if so, do you need legal assistance in bringing your claim? But if your employer fired you as a preemptive strike because you were going to go on sick leave, i.e., if it knew about it, then that can assist you, or would form an anchor or a justification for you claiming or bringing a human rights complaint. And that human rights complaint can bring you additional compensation. So you'll certainly want to talk to an employment lawyer. Lily, I sound like a broken record, but you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, Liz again. "I'm due to return from sick leave with a new disability, needing accommodations, and I'm being told to double the workload. We don't babysit," said the manager, being 1 year on the job. Okay, so I think, so you're coming back from sick leave, but you now have a new medical issue and you need accommodations. So you need to provide uh, I would just, you need to medically paper everything that you're doing here. So go to a doctor, get what your accommodations are, send those by email from your personal email to your manager. And the reason why you do it from your personal email is so you have a history of it, right? You have a paper trail which shows what you said. Here's the medical notes and the dates. Okay, and they have a duty under the Human Rights Code, human rights legislation in your province or federally, to accommodate your disability to the point of undue hardship. Now, if they don't, what are the penalties? they may choose to not. You've only been there for 1 year, so they can also probably terminate you, and the cost won't be that great. Although certainly there would be a human rights exposure for them there, and sort of also potential bad press, we'll call it, of terminating someone who has a disability. Um, but you don't know yet. I don't know uh, if you've provided your medical documentation to your employer, but I would do that right away and see what they do. And I guess the question is, what are the accommodations you need, and what are they refusing to provide? And I don't have that information. Um, there are certainly some employers who will refuse to provide those accommodations, and then the question is, well, in its refusal, can you do the job? And if you can't, have they effectively terminated you? Was it reasonable for the employer not to provide you those accommodations? It sort of gets into all that. But in order to advance a claim, we'll say for compensation, you want to make sure that the value is there. And if you're only there for 1 year, it might not be. So this might be something that you bring yourself through the Human Rights Tribunal. Apologies for that interruption. Sorry, I call it the Human Rights Tribunal because that's what we call it in British Columbia, but it has a different name in different provinces. So whatever your human rights regime jurisdiction is governed through, that you might want to bring this complaint through that. But I would talk to an employment lawyer anyway, because you've already been terminated and you need to assess what your potential severance is and what your legal position is. Okay. How would you suggest? I'm not going to identify this person's name because it's unique. Sorry, before I do that, Liz says that she's in BC. So certainly in BC, Liz, it's you can bring your complaint before the Human Rights Tribunal, and it doesn't cost you anything. It's just that there's a approximately 4-year backlog for an adjudication, so it's a while. You can get a mediation faster if the other side agrees to it in approximately a year. But I would really rely on your medical documentation from your doctor, where you provide this to your employer and say, look, this is what my doctor wants. Um, is this a permanent disability, or is this one that might last 3 months? But I would really rely heavily. I would really rely heavily on what your doctor has to say. And if they want to go against what your doctor has to say, that just leaves them more exposed. Okay. So this person, I'm not going to identify their name because it's unique. How would you suggest to deal with a toxic work environment? My wife is being treated very poorly by coworkers, and management seems to be turning a blind eye. Yeah. So bullying, harassment, toxic work environment. Um, Employees are constantly surprised to find out how limited the legal protections are under those headings in employment law. So if you are being bullied and harassed and the employer is doing nothing about it, it can be a constructive dismissal. But so just bullying and harassment from your peers is not going to get you there. From your manager, it could get you there. But if you bring it to the employer's attention and they do nothing about it, it can be a constructive dismissal because you're entitled to a harassment-free, safe working environment. But the courts aren't going to commercially criminalize, for lack of a better term, tension and disputes between humans in the workplace. Humans don't, they don't always get along, right? The courts don't want to interject and create legal consequence for people just having a bad relationship, right? You don't want a situation. Generally speaking, we don't want that level of intrusion from the courts. And so what I'm saying is, if you are experiencing that level of harassment, it has to rise to the level of egregiousness to ground a constructive dismissal. And you have to have a lot of evidence of it. And it's hard to get evidence of it, but emails, maybe you take a video or two, but don't take too many of them. keep a logbook. I would keep a logbook of, dates and what happened, and who was involved. I will say this, just in my own experience, 80% of people I talk to mention some degree, well, maybe not 80%, but it's pretty high, mention some degree of bullying and harassment, and almost never does it have legal significance. And a substantial portion of the time, it's not objectively bullying and harassment, right? Because you subjectively might feel this was bad behavior, but there's a difference between your manager not being a good manager and objective bullying and harassment. So, and I'm not saying that that's not the case with your wife. I'm saying you want to make sure that you get a lot of evidence, that she records everything in a journal, and before you do anything, you need to talk to an employment lawyer, because claiming that the employer, and certainly you're going to want to bring it to the employer's attention, but I wouldn't do that without talking to an employment lawyer first, so the employment lawyer can coordinate it, because a constructive dismissal grounded on bullying and harassment is very, very difficult. It's very, very difficult. You got to have a lot of evidence for that. I will say that if you have a claim already for severance, then the bullying and harassment and the lack of doing anything about it could provide some assistance with general damages, or sorry, I should say punitive damages claim. But it's not something to really hang your hat on in that regard. So you'll want to make sure that she has a lot of evidence and records everything, keeps a journal, etc. But if it's that bad, she may also want to consider just leaving and going and working somewhere else, right? Like that's always available to employees. If you are unhappy in your workplace, you don't think it's going to change, you're still drawing a paycheck from that workplace. Cast your net out and see if you can always, elect to cast your net out and see if you can get a better job somewhere else. Right? I mean, if you got 20 years in the place, then that's probably not something you want to do, or it may not be something you want to do, but it is an option that is available to you in a free market society. Okay. Paul asks, can an employer dock 15 minutes of pay for being 1 minute late? Well, I think a better answer to that question is, or an answer to that question is, even if they can't, what are you going to do about it, right? Like, what is your remedy? You're not going to put your job in jeopardy for 15 minutes of pay. You're not going to bring a claim for 15 minutes of pay. I think this is one where if it's gotten to the point between you and the employer where 1 minute late equals a 15-minute pay deduction, it sounds like the relationship is kind of sour, or has soured, and maybe you want to consider looking around and moving somewhere else. Now, that's not always possible. It could be you work at a high-paying job in a small town in a factory, and that's the only game in town. But that's the kind of thing that if it's out of the blue, well, let me rephrase that. It indicates to me, just looking at it from a 50-foot perspective, that the relationship isn't going well. And so, what can you do to rectify it if you want to stay, or should you move on? But in terms of can they dock you that, I don't know the answer to that question. But more importantly, even if they couldn't, what are you going to do? What's your remedy? And the answer is you don't really have one. Karen asks, what steps do I need to take when my former employer does not honor a severance pay package? The waiting period at ESC is 8 to 12 months. Oh, you're talking about the Employment Standards Branch? Yeah, no, it's quite long. So EI, you want, sorry, does not honor a severance package. Well, you can apply for EI right away. That's what EI is for. So you should talk to Service Canada and do that. You should just talk to Service Canada and do that. And then in terms of honoring a severance pay package, there are, well, it depends. I mean, Karen, is this a working notice situation, or is this one where you've agreed to severance and signed a release in exchange for it, and they're just not following through? Because if it's the second one, you can sue for it. If it's the first one, then right. Okay. Um, Karen, you're in BC, correct? Sorry, Karen said yes to what I said. Right, right, right. Karen, did you call me today? So Karen said it is in fact working notice. Um, why don't we discuss that, Karen, offline after this? Yeah, we'll Karen, I'll send you an email later today, and we can try to connect later today, okay? And we can get this sorted out for you. Yes. All right. Okay. Karen said that she did. Yes, I will. Karen, I will give you a call later today, and we can sort that out. Okay. I did get your voicemail. I just haven't had a chance to give you a call back. Justin asks, can the employer hang their employees' country of origin flags in their facilities without their consent? I don't. I don't understand the question. So you work somewhere, and certain employees or management are hanging their country of origin flags in the facility. Well, if it's just employees, I would think you'd want to get employer permission before doing that. If it's just the employer, uh, I don't. I mean, is it controversial? It could be. There's a lot of controversial things happening in the news right now. Excuse me. So I guess the question um, does it offend your political beliefs and such that it's a human rights violation? I don't think so. It's just not something a question I've ever thought about. Again, what's your remedy? And and I guess more importantly, or equally importantly, what's the offense of doing so? Is it something that is problematic for you, or you just want to know? For a lot of these things, it's you've got to determine what is your remedy, and what is the legal remedy, and what is the consequences of pursuing your remedy, right? Like, so the guy I was talking to earlier, who was unhappy with the fact that they docked him 15 minutes of pay. Yeah, I mean, it's not great that the employer did that, but are you going to sour the relationship completely by bringing some sort of action, or redress remedy for that? Probably not. And if you did, the costs of doing so would dwarf what you'd get in return. And so with this flag thing, you could choose, if it's coming from ownership, you could choose to make a big deal about it. You may have a human rights complaint. I'd have to think about that a lot more. Um, but what would happen to your relationship with the employer? Would it be soured forever? And so, is it something that's just fundamental for you and you can't abide, or is it a minor annoyance? So, with a lot of these things, you got to think about what the relief is, and what are the consequences of pursuing the relief. I will say, for almost all of you, if your plan is you want to continue to work at that particular employer, pursuing relief through legal means is going to sour the relationship. So, uh, do we have any more questions? Oh, we have a couple more. Oh, it's one more question. I'll answer that now. But just always think about that when you're, because a lot of people get upset about things that the actions the employer takes, but you have to put it in the context of, well, what's going to happen if I fight back against this, and should I, and is it worth it? Because lots of times it is. But lots of times it isn't too, as well, right? Some things are of proportionally smaller in import than other things. So, um, I'm not going to identify this person's name either. I think my employer is underpaying me because of my race. Everyone else in my position is making a bigger salary. I want to ask for a raise, but I'm afraid they'll be fired if I do. Is there anything I can do about this? Um, well, that's a really tough question because of what we just talked about. If you'd be bringing a human rights complaint. There is There is new legislation on pay transparency. To be honest, it just came out. I haven't had a chance to really get under the hood of it. I don't know if it's specific to, like, if it covers race, gender, sex, sexual orientation, all of it, or if it's just for one piece of those different groups. So that might assist you there. Uh, Generally speaking, if you're being underpaid due to your race, it's a human rights complaint. But like I said earlier, if you bring a human rights complaint, are you going to continue to have a job there, right? I mean, you wouldn't they wouldn't fire you right away, but I'm sure over time they'd probably try to figure out a way to get rid of you. So it's that level of risk. Taking that on is difficult. It's a decision that you have to make. And you know what? You should probably talk to an employment lawyer. You could do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. I think, though, people have got to also remember that employers pay different individuals differentially in the same positions based on performance, based on a variety of different things, seniority. Sometimes it's because the one individual is buddies with the owner's son or something. It's there are different reasons for differential pay, and it's not always discriminatory that there is differential pay. But where there's a broad track record of it, then that would be discriminatory. But on an individual basis, it might be very, very hard to prove. But if, for example, there's 10 people and let's say there's 50 people in the same position across the entire company, and 10 of them are all one particular race that is different from the majority race, and those 10 are being paid 25% less on average, yeah, you might have something there, and be easier to prove. But when you're talking about one individual, that might be harder, right? So I'm kind of with you with what you kind of indicated, that you're a little scared to bring it up, and I think that's probably the right instinct. And then you ask, well, is there anything I can do about this? Well, I mean, if you're right and it is because of race, probably not. You probably have to be prepared to bring the complaint, walk away, and go do something else. You bring a constructive dismissal, but you'd want to really get legal advice on that and make sure that you bait the employer into taking actions that assist you there. But if it's not, what can you do about it? If you're incorrect, it's not because of race. That's the sort of standard stuff you do with any employer. You work harder. You bring to their attention that you want more work and more opportunities, and you're a team player and all that stuff. I mean, it's how you get raises and promotions generally, right? So I think you got to really, really think about why you think that, and then if you think that you are correct after giving it a sort of a long analysis, then you've got to ask the question of, well, are you prepared to stay given that? Because if you are correct, your opportunities over time are going to be reduced, right? So, and if you're not prepared to stay, then talk to an employment lawyer and sort of marshal a strategy to exit with as much money as possible. Okay, we're way over time now. So thank you all for the great questions. Again, you can reach us if you want at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. I'm Dan Balkaran. Thanks for those questions. They were wonderful. Join us again on Monday. What is that? 1:30 Eastern time with Chris Justice. He'll be answering all your questions, employment law. Other than that, there I am, Dan Balkaran, associated Samfiru, Tumarkin. Other than that, have a wonderful and safe weekend, and I will see all of you in 2 weeks.